All rise.
My Lords, my Lady, just very briefly before Mr. Swift recommences his reply, may I just mention anonymity?
Yes.
And ask for the orders which my Lord, my Lady made on Monday to be extended until further order. They were due to expire today.
Yes, they were, and they should be extended until further order.
Thank you very much.
My Lords, my Lady, there are 5 matters I need to cover in the course of my submissions this morning. They are, firstly, Mr. Singh's submissions as to the effect of the common law. Secondly, his submissions in relation to Cardi. Third, the question of overruling Al-Jeddah. Fourth, effective remedies, and within that I will include my response to the points made by Mr. Hussain in respect of HAY. And fifth, in respect of the absence of express provision for a special advocate procedure and the absence of an exclusion from the prohibition at Section 17 of the Regulation of Investigatory Powers Act. Turning to the first of those matters, could I ask you just to have to hand Mr. Singh's one-page summary from yesterday morning, if that's convenient? Now,
the one that's headed Outline of Submissions for Appellant.
My Lord, that's correct, yes. The first 5 paragraphs of that document are all based only on the application of the common law and only the common law. Now, looking at paragraph 4, Mr. Singh there identifies 5 fundamental rights. Now, those are the rights that he says, as a matter of common law, bring into play the principle of legality in the present case. Could I deal first, and hopefully relatively briefly, with the second and third of the rights he identifies at paragraph 4? In relation to those, the Treasury's submission is as made in relation to the appeals of A, K and M. That is to say that neither has been recognised by the common law as a fundamental right for the purposes of legality. Mr. Singh has cited no authority for the proposition that either is recognised for that purpose, but even if they were so recognised, and the principle of legality operated in relation to them, G is in the same position at common law in respect of the Al-Qaida order as he is, and as are A, K and M, in relation to the terrorism order. Now, the Treasury's submissions on this point are set out at paragraphs 60 to 64 of our printed case in G's appeal. But could I just summarise those very briefly? Firstly...
Which case is it? You've got several... Is the case
I'm sorry, in G's case,
in
my
G's
Lord.
case, thank you.
Sorry, which paragraph numbers?
It's paragraph 60 to 64, my lady. In summary, we say this, that the power at Section 1 of the 1946 Act plainly anticipated that it would be used in order to interfere with property rights. Again, by reference to the purpose specifically linked to decisions taken under Article 41 of the Charter. And so that possibility of interference with property rights could not, in the words of Lord Hoffman, have been something that would have passed unnoticed in the democratic process.
Is that right? I'm looking at Article 41. It talks about economic relations. Is that what you mean? I mean, when it refers to, I'm looking at Article 41, as I say, the interruption, complete or partial interruption of economic relations, means of communication, and so on and so forth. You say that extends to property rights.
I do say that for these reasons. Firstly, even if one looks simply at the words economic relations and assumes, for present purposes, that what, for example, a situation where sanctions are directed to a particular state, don't trade with country X. Now, even in that situation, giving effect to the prohibition, don't trade with country X, will mean that Mr. A and Mr. B, who have businesses or want to send money to their relatives in country X, won't be able to do that. And so it will directly affect their property rights.
Consequentially, at least, if you have the economic relations between country A and country B interrupted, you say that will affect property rights as a consequence.
Yeah. Well, as a consequence, as an inevitable consequence. There is also the further point that we outlined in relation, in the course of our submissions on AK and M, and that is that the list within Article 41, we say, was plainly not intended to be an exhaustive list. One's seen that from the Simmer commentary. And also, one simply has to have in mind the purpose of Article 41. There was no attempt to try to anticipate what threats to peace and security might be identified by the Security Council, and equally, no attempt to anticipate what measures might be regarded as necessary in order to respond to those threats.
Article 41 is inevitably going to involve stopping individual citizens from doing something which they would otherwise be allowed to do.
Indeed.
The question then arises, well, what if it's not using their property? Or whatever right you think of, you tend to come to the conclusion that this is going to involve one of the human rights.
Yeah, yes. Well, for these purposes, it's the common law rights that Mr. Singh relies on, not convention rights.
But even so.
But yes. But if one puts it in the human rights context, yes, I agree, my lord, the conclusion must be the same. That deals, as it were, with Mr. Singh's second right. Now, number 3, the rights of privacy. Again, our printed case deals with this at paragraph 68, just for your note. But in short, neither G's printed case, nor in fact his pleaded case, provides particulars of what it is said amounted to interference with the common law right of privacy. However, even if one assumes that what G has in mind are, for example, the matters referred to in his witness statement, which set out the consequences for him of the economic measures, those matters are in fact precisely the same matters that constitute the interference with his property rights. And so the interferences, as it were, are identical. Now, to that extent, the same analysis applies in relation to whether the possibility of interference with rights of privacy would have gone unnoticed in the democratic process, as applies to rights of property or rights to property. And so we say precisely the same analysis applies. And in terms of the argument based on the principle of legality, neither the second or the third rights that Mr. Singh has identified actually assists him in the present case.
Can the matter be put slightly more broadly? Because both the right to property and the right to privacy are inherently very qualified rights.
My lord, yes.
And that seems to me one relevant factor when considering whether something is a fundamental right.
Precisely, my lord, yes. Respectfully, I would agree that it does go to the point as to whether, for common law purposes, these are rights which engage the principle of legality at all. May I now turn to deal with 1, 4 and 5 on Mr. Singh's list at paragraph 4 of his note. In practice, we say that all 3 of those come to the same thing on the facts of this case, that at common law there is a principle that a person should be able to challenge in a domestic court the substantive reasons for the decision taken at the international level by the Security Council. That is what we say is Mr. Singh's case in relation to 1, 4 and 5. Now, in response to a question from my Lord Mance yesterday, Mr. Singh confirmed this when he said that the hearing would be on the issue of whether there was a factual basis for putting G on the consolidated list. That's the 1267 committee decision. But, on the other hand, Mr. Singh also relies heavily on the point that the decision of the Security Council, or the 1267 Committee, that G should be on the consolidated list, by itself has no effect as a matter of English law.
Has no what?
Effect as a matter of English law. Now, he attempted to say yesterday, in response to a question from my Lord Hope, that what had given effect to the decision in English law was some act on the part of the Treasury. So far as I can recall, Mr. Singh was not particularly specific as to what that act was, but he mentioned the act of notifying G that he was subject to the provisions of the Al-Qaida order. That answer, with respect, is plainly unsatisfactory. If that is the Domestic Law Act that is to be subject to challenge, it simply begs the question, what was the basis in domestic law for the Treasury to give the notification or to do whatever other act it is that Mr. Singh identifies?
I mean, as it's a pretty basic question. I shouldn't need to ask at this stage, but as I understand it, under the Al-Qaida order, you've got the order, you've then got somebody put on the 1267 list, and without more, they are subject to the order.
Indeed, my lord, yes. As Article 3.1b is drafted, it is the fact of designation that is the governing criterion.
But of course, that requires putting into effect in this country, and the Treasury does that, and they do it by notifying G in the letter. I was reading the letter yesterday, I forget where it is. And of course, the other thing they do is notify the banks.
Yes, but my lady, notification is not a precondition for the application of the order.
I'm not making any comment on the substance of the argument that you're putting forward. I'm merely saying, as a matter of fact, what happens is the Treasury learns that somebody's been listed, the Treasury then notifies that person of what that means and notifies the banks that they've got to stop all their money.
And say hypothetically that notification, that act of notification was subject to a challenge for judicial review, and the Treasury was called upon to explain why it had notified. The answer would be a simple answer. It would be Article 3.1b, because of the fact of designation. And so it doesn't get you back into the decision that Mr. Singh wants to attack, which is the decision of the 1267 Committee. As I say, we say the proper question is what is the basic in domestic law for that notification? And the answer is Article 3.1b. The notification was simply because of the fact of designation. Just so the position is clear, the Treasury fully accepts that the principle of legality requires that decisions of domestic executive bodies, including the powers of executive domestic bodies to make secondary legislation, should be subject to scrutiny by the courts in accordance with domestic law. That, we say, is the scope of the principle as identified by the House of Lords in Boddington. Could I just give you the reference to that in the authorities volume rather than take you to it? It's volume 4, tab 25, and it's the speech of Lord Irvine at page 161D to E. If it is convenient, that passage is also set out in full at paragraph 44 of our printed case. So we accept that principle applies. We do not say that the principle is excluded or ousted by the provisions of the Al-Qaida order or by the provisions of Section 1 of the 1946 Act. But what we do say is that if the principle is to be properly applied, it is vital to identify what is the domestic law provision or decision that should be scrutinised in accordance with the principles within the notion of the right of access to a court. Now, on Mr. Singh's case, the claim that the court needs to hear to give effect to this principle concerns the factual basis for including G on the consolidated list. That is not a decision taken by any domestic executive body. Again, the operative provision is 3.1b, which operates simply by reference to the fact of designation not by reference to the merits of the 1267 Committee's decision. We say that the need properly to identify what is the relevant measure was demonstrated in Mr. Hussein's submissions yesterday. Now, yesterday, he gave the example, he said, well, what if the provisions of the Al-Qaeda order were such that the order only applied if a direction were made by the Treasury? And then there was an ouster provision within the order that prevented that direction by the Treasury being questioned before a court. Now, he said that on that example, the legislative ouster provision would be struck down as contrary to the principle of access to a court. Now, that's quite correct. It probably would be. But the important point to note is that is not how the Al-Qaeda order is drafted, and that is not how the Al-Qaeda order operates. Before continuing with the submission, could I deal briefly with Article 3.1c of the Al-Qaeda order and directions under Article 4 of the order?
Would you remind us where the order is?
Yes, there are various, they're all in Volume 18. There are various versions of it. I think yesterday you were looking at the version at tab 150, which is the as-made version.
Yes.
Now, Article 3.1c is again it's the application provision, but provides that the order applies to any person identified in a direction, and then the power to give a direction is at Article 4. The conditions are at Article 4.2. Reasonable grounds for suspecting the person is or may be Osama bin Laden, a person designated by the Sanctions Committee, then C or D, a person owned or controlled, or D, a person acting on behalf of. Now, in relation to B, which is the point in issue for present purposes, that is directed to situations where there is a dispute as to identity. Now, the use of aliases or the use of a number of names concurrently is a far from uncommon situation in this field. And so the issue might be, well, the 1267 Committee has added the name of Mr. Smith to the consolidated list, and the issue is whether somebody who calls himself Mr. Jones is in fact Mr. Smith. And so if there is a challenge to a direction made under Article 4, the issue will be whether or not there are reasonable grounds for the suspicion as to identity. It will not entail any consideration of the substantive merits of the decision of the 1267 Committee. And so, as to G's reliance on the common law principle of the right of access to a court, our submission is this. Firstly, the proper focus of attention has to be the relevant provision in domestic law. Secondly, that provision is Article 3.1b. Thirdly, properly construed, the effect of that article is that all persons designated by the 1267 Committee should be subject to the provisions of the order, and that is the only governing criterion. And fourthly, for the same reason, the reasons why the 1267 Committee took its decision are not relevant as a matter of domestic law. And so Mr. Singh's primary submission, that there must be a hearing before the court to consider the factual basis, is not a submission, we say, that can be made good by reliance on the principle of the right of access to a court. It would be to use that principle as a means of importing into domestic law a decision that has not been taken by any domestic executive body, and to bring it into domestic law simply for the purposes of permitting the decision to be subject to challenge.
But isn't the approach a rather broader one? We're simply dealing here with construing the scope of the order. And if looking at it broadly, the object of the exercise is to freeze the property of somebody who is involved in terrorism, broadly you can say, well, it's going to be a bit surprising if it falls within the order, if the vital decision as to whether the person is involved in terrorism is being taken by a body and not susceptible to challenge in the English court. I mean, all one's looking at is how likely is it that this is what the legislation was intended to achieve?
Well, if one looks at it from that perspective, I think there are at least two matters one needs to bear in mind. Firstly, Section 1 of the 1946 Act itself, an express power to give effect to Security Council decisions. And so Parliament clearly appreciated, when it was making that bit of legislation, that the United Kingdom would be at the forefront when it came to implementing United Nations sanctions. And that is entirely natural, given that the United Kingdom is a permanent member of the Security Council. And in practice, of course, many countries, not the least the Commonwealth countries, do take their lead from the United Kingdom. And so if the United Kingdom were to default on its international obligations, the consequences of that could be far-reaching. That's the first point, the purpose of Section 1. And secondly, the decision of the Security Council in this case. Now, could I take that decision from Resolution 1822, which is the consolidated version of the resolutions? That's in volume 19 of the authorities at tab 175. And paragraph 1 of the resolution, the operative paragraph 1 on the third page, a requirement that all states shall take the measures imposed, going down to the third line, with respect to Al-Qaida, Osama bin Laden and the Taliban, and other individuals, groups, undertakings and entities, as referred to in the list created pursuant to Resolution 1267. So that is the obligation, is that all member states should take the same action against persons identified collectively at the international level. And as you have seen, that has been the consistent approach of the Security Council in each resolution since Resolution 1390, which was made in 2002. Now, in those circumstances, we say it's not at all surprising that the effect of the Al-Qaeda order is premised on the operation of a provision in the terms of Article 3.1b, because that is the provision that clearly effectively implements the decision of the Security Council taken in this case. The reasons for that decision, the Security Council decision, are of course reflected in the resolution itself. And perhaps just for your note, in the preamble, there are 3 paragraphs we say that are indicative of the threat that the Security Council had identified, and those are the first preamble paragraph, simply by reference to its recitation of all relevant Security Council resolutions, including, I would ask you to note, Resolution 1373. Then also the paragraphs, the 8th paragraph, which is the second paragraph on the second page, stressing that terrorism can only be defeated by a sustained and comprehensive approach involving active participation and collaboration of all states and international and regional organisations to impair, isolate and incapacitate the terrorist threat. And then also paragraph 9, which emphasises the importance of sanctions as a tool in order to maintain and restore international peace and security. The decision of the Security Council is such that the threat recognised or identified was a threat from a global terrorist network, and the response to that threat was that there should be a global asset freeze in terms and against persons identified at the international level. So there is no option for a member state to go behind the resolution and decide for itself to whom sanctions should be applied. And, my Lord, in those circumstances, and again returning to the way in which Mr. Singh puts the case for G, it's important to recognise what the consequences of his submission would be. Those consequences would, of course, apply not only to Resolution 1822, but would apply to any resolution taken by the Security Council. For example, a requirement to impose a travel ban on President X, or indeed, as we have within 1822 itself, a requirement to impose economic sanctions upon Osama bin Laden. Now, on Mr. Singh's submission, there would be no requirement on any member state to give effect to that decision without first justifying the reasons why the Security Council had taken that decision to the satisfaction of its domestic courts. But the same logic would apply equally to a refusal on the part of a member state to comply on the basis of actions by its legislature or its executive. It's not just the question of the judiciary. And that would be the same whatever the ground for non-compliance, and that would apply to all 192 member states. And so it would be all too easy for the entire purpose of the Charter, effective collective action, to be entirely removed. Now,
as I understood, one part of the argument yesterday against you was that the United Nations, the obligation imposed by Security Council, imposed by Article 103 and so on, is to do what any individual state is capable of doing within its own legal order to comply with the obligation. Whereas I think you're saying, and I'm just trying to clarify my own mind, you're saying that the obligation is actually to do whatever is required to put your legal system into a position in which it can fulfill the Security Council obligation.
Well, precisely so, yes, precisely so. Yes, and just to work through the consequences of not doing that, well, one would have a situation where one returned to where the international community was under the League of Nations, a situation where sanctions would only be applied by each member state if it chose to apply them. And so one would see that there would be a significant destruction of the system of international cooperation and international action that is embedded within the Charter. Now, Mr. Singh's response to that is simply, well, so be it. And I understood his position to be exactly the same, or would be the same, if he was faced with not the Al-Qaeda order, but the Al-Qaeda Act. He would say, so be it, and in those situations, this court would simply grant a declaration of incompatibility in respect of the Al-Qaeda Act.
Do we have, I don't think we do, a Security Council Resolution 1456 of 20th January 2003, because I was reading an article in the International and Comparative Law Quarterly this year, page 229, which
I think that is at, so 1456 is at tab 167.
We do have it, do we? Because that contains, sorry, which one?
I'm sorry, volume 19, tab 167. Yes, that's the declaration.
Yes, this is this contains statements saying, yes, that's right, paragraph 6.
Yes.
States must ensure that any measure taken to combat terrorism comply with all their obligations under international law and should adopt such measures in accordance with international law, in particular international human rights, refugee and humanitarian law. Now, doesn't that reflect the overriding interest of the United Nations in ensuring that any measures are implemented at the national level in a manner consistent with international human rights?
Well, my Lord, we say no. Firstly, 1456 is not a resolution under Chapter 7. It's simply a decision to adopt a declaration.
Yes.
Well, perhaps I can deal with it in this way. The point was directly addressed by the Strasbourg court in Barami. And we say that the answer given in Barami makes it clear that, in fact, that is not the consequence of Security Council obligations as they apply by reason of Article 103 within the system of Strasbourg law. Now, Barami is at volume 16. Tab 131. Could I ask you to go to paragraph 147, please?
But Barami is a sidestep, isn't it? Didn't they say, basically, this is the UN?
Well, ultimately, the decision was a decision on attribution, yes. But my Lord, 147 to 148, we say nevertheless set out...
this is considered by the Advocate General in Cardi, and he distinguishes Barami on the ground I mentioned, and he says that the most closest analogy is actually Bosphorus, which is a precursor to Cardi, in his view.
Well, my Lord, could I ask you to look at paragraph 147, yes, please?
140.
147, my Lord.
Yeah.
The Court first observes that 9 of the 12 original signatory parties to the Convention in 1950 have been members of the United Nations since 1945, that the great majority of the current contracting parties joined the UN before they signed the Convention, and currently all contracting parties are members of the UN. Indeed, one of the aims of this Convention is the collective enforcement of rights in the Universal Declaration of Human Rights of the General Assembly of the UN. More generally, it is further recalled, as noted at paragraph 122 above, that the Convention has to be interpreted in light of any relevant rules and principles of international law applicable in relations between its contracting parties. The Court has therefore had regard to two complementary provisions of the Charter, Articles 25 and 103, as interpreted by the International Court of Justice. Now, my Lord, you see there the reference to paragraph 27 above. Could I ask you just to go to that before we continue with 148? Paragraph 27 is on page 10 of the report. So in connection with the Court accepting the interpretation of Articles 25 and 103, back at page 10, paragraph 27, the Court has set out the jurisprudence of the ICJ on this matter. The ICJ considers Article 103 to mean the charter obligations of UN member states prevail over conflicting obligations from another international treaty, regardless of whether the treaty was concluded before or after the UN Charter or was only a regional arrangement. References there to Nicaragua. And
Cardi at first instance.
Cardi at first instance, yes. No, I can't avoid Cardi at first instance, and I'll come back to Cardi in the court in a few moments. And then halfway through the paragraph, the ICJ has also found Article 25 to mean that UN member states' obligations under a resolution prevail over obligations arising under any other international agreement. And so the Strasbourg court here is accepting that, and one would have thought that if my Lord's proposition was correct, the Strasbourg court would be saying, well, yes, up to a point. And the point being, they don't override or displace obligations under this convention. But that's not what the court says. Now, if one goes to paragraph 148, which is back on page 42, one sees what the court does say in relation to the relationship between the convention and the charter. And it says, of even greater significance is the imperative nature of the principal aim of the United Nations and consequently of the powers accorded to the Security Council under Chapter 7 to fulfil that aim. In particular, it is evident from the preamble, Articles 1, 2 and 24, as well as Chapter 7, that the primary objective of the UN is the maintenance of international peace and security. While it is equally clear that ensuring respect for human rights represents an important contribution to achieving international peace, the fact remains that the UNSC has primary responsibility as well as extensive means under Chapter 7 to fulfil this object, notably through the use of coercive measures, I'd add in brackets, and also Article 41 measures. The responsibility of the Security Council in this regard is unique and has evolved as a counterpart to the prohibition, now customary international law, on the unilateral use of force. In the present case, Chapter 7 allowed the Security Council to adopt coercive measures. I don't know if I could go down 6 lines. Actually, no, I'll start at the next paragraph, since operations. Since operations started by Security Council resolutions under Chapter 7 of the Charter are fundamental to the mission of the UN to secure international peace and security, and since they rely on their effectiveness on support from Member States, the Convention cannot be interpreted in a manner which would subject the acts and omissions of contracting parties which are covered by Security Council resolutions and occur prior to or in the course of such missions to the scrutiny of the Court. So the Court itself is clearly identifying where the hierarchy is and what the effect is of a Security Council resolution.
I mean, you say, so far from it being surprising and unsatisfactory that under the Al-Qaeda order there's no basis for challenging the factual reasons for somebody's designation on the consolidated list, it would be astonishing and destroy the whole basis of this United Nations process if it were.
Indeed, my Lord, yes. Yes. And perhaps to address my Lord Mance's point in a different way, and this also stems from an observation made by my Lady Baroness Hale yesterday morning, I think. And she made the point that there was nothing in the Security Council resolution that says a person is deprived of a right to a fair hearing. Now, with respect, and this answer I hope addresses my Lord Mance's question too, that begs the question, a hearing, access to a court, on what issue? Now, if the domestic provision here is properly analysed, and the relevant domestic measure is the decision to apply the order to all persons identified by the Security Council, on that basis there is nothing in the Security Council decision that prevents a hearing in these courts on the legality of adopting that measure.
Well, I mean, one sees all that, obviously, but the essence of the reasoning in Cardi is that although property and privacy aren't as such fundamental rights, the fact is that you can't remove them or fundamentally affect them in the way that was done without giving people an opportunity to object judicially to the basis on which that is said to be justified. And I know you say the basis is said to be simply that the UN has decided, but that's not an opportunity to deal with the substance. That's the substance of the reasoning as I see it. And there is a fundamental right to that extent.
Well, my Lord, I'll attempt to deal with Cardi in more detail in a few moments, but could I just for present say this? Firstly, Cardi is dealing with the position of the European Convention on Human Rights within community law. So firstly, it's not dealing with common law rights, obviously. It's dealing with convention rights, but it's dealing with them in the context of community law and how they apply within community law. It's also dealing with a different measure. The provisions of Regulation 881 are important, and I'll take you to these in a few moments, but for present purposes, I'll just say this. The way that Regulation 881 is drafted is that the regulation applies to a person only if his name is added to Annex 1 of the regulation or already appears in Annex 1 of the regulation. And then within the regulation, the Council is given specific power to add people's name to Annex 1 to the regulation. Now, that is a power that is said required to be exercised in accordance with or rather to reflect decisions taken by the 1267 Committee. But nevertheless, there was a community measure taken by a community institution, which was in Cardi, entirely unsurprisingly, subjected to legality testing on the basis of community law. And the Al-Qaeda order is not the same. And what I will be saying, once I've taken you to Cardi, is that if one applied the reasoning of Cardi, taking into account the differences between community law and the common law, and simply applied that reasoning to Article 3.1b, one would reach the result that the correct measure, the domestic measure, was Article 3.1b.
So if one had had a statutory instrument which said the following people should be subject to all these prohibitions, namely those contained in the annex, and the minister shall be empowered to include in the annex all those who are identified, designated by the UN committee, then that would be a Cardiff situation entirely different, and we could review the minister's decision as to whether it was appropriate to give effect to the UN designation.
No. Important thing about Cardi, and this is a bit like question of sport, no one knows what happens next.
Well, I think we do. We know very well what happened next. By Commission and Regulation of the 28th November 2008, the Commission amended 881 and said that it had given Mr. Cardi and the Al-Barakat International Foundation opportunity to make comments on the summaries of reasons provided by the UN. It had considered the comments. It decided that the listing remained justified, and so Mr. Cardi and Al-Barakat are precisely back where they were before.
But, my Lord, so in that case, the Commission took the view that their reasons for adding Mr. Cardi to Annex 1, effectively they adopted the reasons of the Security Council.
But they had some reasons to look at.
But my Lord, it would be an equally valid approach in the context of Regulation 881, when asked, why did you add my name to Annex 1, to say, well, I did it because your name appears on the Security Council's list.
Can we get back to the approach I was putting to you, which is, when we're looking at common law rights, we're only looking at them to help us to construe the scope of the order. That's what it's all about.
Indeed.
And all things being equal, it might be surprising to find Parliament giving the executive the right to impose severe sanctions on citizens of this country on the basis of findings made by an outside body. I mean, on the face of it, that's going it a bit. I think your answer is this, but look at the context.
Indeed.
In the context, although all things being equal, one would find it surprising, it's not surprising in this context. Is that what it boils down to?
I'm sorry, well, yes, yes. That is my response in a sentence, and the context is the Act and the resolution of the Security Council and the interplay of those two matters. Sorry to have given a half-hour answer when it could have been said in a sentence. So, although Mr. Singh says, well, the answer is the opposite and just so be it, one sees from Barami that that is not the answer that the Strasbourg court would give, and we say that it's not the answer that is required as a matter of common law. And we say that the issue before you does come down to a relatively narrow matter of construction of Article 3.1b of the order itself. Our submission is that that article is specifically drafted by reference to the outcomes of decisions taken by the 1267 Committee. It distinguishes between the outcomes and the merits of the decisions themselves. It does that for an entirely unsurprising reason. That is to say, that is the effective way, and certainly a permitted way, of giving effect to the decision taken by the Security Council. The Security Council was not inviting member states to assess for themselves the merits of the 1267 Committee's decision. It was instructing and requiring member states to apply the results of that decision-making process. That is to say, to apply the sanctions to those who were named on the consolidated list. And we say that there is a clear distinction within Article 3.1b between the domestic measure, which simply looks at the outcome, and the international decision, the merits of the 1267 Committee's determination itself. Now, that much, of course, is clear when one considers the position in HAY, because in that case, one has a situation where the Foreign Secretary has decided that HAY, so far as he, on the basis of the information that he presently has, no longer meets the criteria for inclusion on the consolidated list. But it is in the nature of effective collective action, in accordance with paragraph 1 of Resolution 1822, that unless and until that decision is reached by the 1267 Committee, the position of the Security Council is that the sanction should still be applied to HAY.
The only body, as the European Court of Justice pointed out, which could review the Security Council decisions would be the International Court of Justice. And reading Professor Tridimas, what he's suggesting is that, in truth, a more satisfactory line of reasoning might be to recognise that, in fact, national courts are not just saying the United Nations Security Council's decisions are necessarily law, but in fact recognising, although they can't judge this themselves, that they might not be law, that in the International Court of Justice it might be held that the Security Council has infringed fundamental principles of international law. Now, no national court can say that, but it isn't necessarily the case that every Security Council decision is in international law valid, is it?
No, of course there are limits.
We can't judge that, but what we can judge is the legitimacy of a national position, and that's what the European Court is saying at the European level. I mean, otherwise, the consequence is one has to just say that the Security Council is always right and ignore the fact that it might be held to be wrong if someone brought it before a court.
Well, with respect to in Cardi, what the Court of Justice was doing was assessing the legality of a measure taken by community institutions. The Court of Justice was very clear to distinguish what its role was. It didn't seek to look at or consider the legality of the 1267 Committee's decision. It was very focused upon looking at the domestic measure and identifying whether that was legal in accordance with
and indeed, that's part of Professor Tridimas's point, that it couldn't do anything more. I mean, I think he is a little critical of it as a Eurocentric decision, but that's his phrase.
Yes, well, I'm not for me to support the European Court of Justice before this court, but it strikes me as being perhaps a slightly odd criticism of the European Court of Justice to describe it as Eurocentric.
No, but I mean, he says that maybe the underlying rationale would be better explained by reference to the possibility, logical possibility, that in fact the Security Council resolution itself, if it were tested at the international law level, might not stand the test.
Well, I would suggest that's a false analysis of what the Court of Justice actually did, for the reasons I gave a few moments ago. And I would also suggest that if one transposes, in principle terms, what the Court of Justice did to the English law context, the outcome is that one tests the legality of the domestic law measure. So one gets back to the question of, well, what does Article 3.1b mean when properly understood and properly construed? And one tests the legality of that measure.
I'm sorry. Beg your pardon, please. At the end of his paper, and this is in volume 12, 93, I think, isn't it? He does appear to applaud what he sees as a commitment by the ECJ to the issue of fundamental rights protection. I mean, there are two chapters, really, to his analysis, aren't there?
Yes.
There's the first chapter and then this particular bit about fundamental rights. And we'll obviously have to read very carefully what he says and read Cardi very carefully, which you're going to come to in a moment, I think. But there is that aspect to it, which...
Sorry, what's this we're looking at?
Well, this is in volume 12, Analysis and Reflections by Tridimas. And it's the only commentary, I think, in the bundles
What tab is it?
93. 93. And I'm looking at the very last page, just for speed, just to where his conclusion is set out. And he says, on the one hand, it empowers the community to play a role in foreign relations and security policy and so on. Well, that's one thing. And then it places fundamental rights at the apex of community edifice. And marvellous, he says that's indeed what it should do.
Well, indeed, and my Lord, in due course, I would agree that that's precisely what the Court of Justice did. It identified the proper place within community law of the Strasbourg system rights. Now, if one attempts to identify the proper place in English law of convention rights, that means one has to identify the effect of the Human Rights Act. This is back to the question determined by the House of Lords in Quark Fishing as to the proper construction of the Human Rights Act, as to say that convention rights were effectively those rights as they were enforceable against the United Kingdom in Strasbourg from time to time.
Well, I thought the present discussion was about common law rather than...
So, I'm sorry, my Lord, it was. I'm sorry, I was only attempting to address my Lord's question. I obviously misunderstood the question.
I mean, obviously it comes into the community discussion, but I'm just seeing what lessons we can draw from Cardi and from this discussion in this paper as to how we approach the common law position in this country.
Well, would it help if I just went straight to Cardi?
I think Can I just ask, I mean, even supposing there were a theoretical possibility of Security Council resolution being held invalid in the ICJ, I think something which hasn't, as far as I know, yet ever happened. But supposing there were, unless and until such proceedings took place and the ICJ had ruled upon it, would countries not have to assume the validity of the just in accordance with ordinary administrative law principles, assume that it was valid unless and until it was set aside?
Well, my Lord, yes, I would suggest that would be in accordance with the basic principles of international law, which of course would be the governing principles.
I wanted to ask you actually, just for completeness, I've looked at two further articles overnight, and one of them struck me as particularly worth reading, and that's by some Sheffield academics in 2009 ICLQ at page 229. There's a comment on Cardi's case note in, I think it's the January edition this year of the International and Comparative Law Quarterly. The other is by Katja Siegler of Oxford in the Human Rights Law Review 288 of this year. And the other point was, I mean, maybe we'll come to it in a different connection, but it might be interesting just to see the report of the Analytical Support and Sanctions Monitoring Team, which is referred to in footnote 47 of the Advocate General's opinion in Cardi, because it says, according to the Advocate General, that the way entities or individuals are added to the terrorist list maintained by the Council and the absence of review or appeal for those listed raise serious accountability issues and possibly violate fundamental rights, norms and conventions. Revisions to the process could help to reduce the possibility of one or more potentially negative court decisions, which was far-sighted. So it might be nice to look at.
Yes, actually, well, if I could have a few moments before I go to Cardi, in response to that question, and indeed a question raised by my Lord Walker yesterday afternoon as to the focal point and case reviews, perhaps I could just give you some information about that. In relation to the focal point, in volume 19 of the authorities, would you be so kind as to turn to tab 173?
One what?
173, my Lord. Resolution 1730 is the resolution that established the focal point procedure. And so it sets out details of what the focal point is. And on the second page of the resolution, one sees that what it is a means of access to the delisting process before the 1267 committee. So the Security Council requests the Secretary-General to establish within the Secretariat a focal point to receive delisting requests. Petitioners seeking to submit a request for delisting can do so either through the focal point process outlined below or through their state of residence or citizenship. And then the tasks that the focal point is to undertake are set out in that resolution. So it receives the request, it verifies if it's a new or repeated request, it acknowledges receipt, it forwards the requests for comments by designating governments, and so on. So it's a process by which a request for delisting, for removal from the consolidated list, can be made. And that process is also identified in the present version of the guidelines of the 1267 committee. Now, yesterday you were taken to the previous version. The present version is also in volume 19 at tab 176. And in particular, paragraph 7, on page 6, the heading delisting, 7b says the petitioner can make the request either directly to the focal point or through his/her state of residence or nationality. And then subparagraph G again sets out the responsibilities and actions that are to be taken by the focal point. And then H sets out what happens if an application is made to the state of residence or nationality. So one sees the process that each state is required to go through to review information that it has, bilateral approach to the designating states, and then 3, if after reviewing any additional information the petition state wishes to pursue a delisting request, it should seek to persuade the designating states to submit jointly or separately a request. Petition state may, without an accompanying request from designated states, submit a request for delisting to the committee pursuant to the no objection procedure. And the no objection procedure is perhaps just for your note at this point, the procedure set out at paragraph 3b of the guidelines at page 2. So that is what the focal point is, and that's a broad outline of the opportunities or ways by which a request...
All you're presently showing us is that the UN process for designation and the possibility of delisting, I mean, isn't as unfair as otherwise it might appear, but your real point is whether it's unfair or not couldn't matter less. We've signed up to it. We have no option but to give effect to the listing whilst it survives.
My Lord, that is my point. I'm taking you to this simply to deal with questions from my Lord Hope and I hopefully also the question from my Lord Mans as to what exists. I just wanted to make...
While we're here, there was just something that slightly puzzled me. On page 5, H. I don't think this was in the previous version. It suggests that there is a website that gives at least some reasons for listing. Is that right?
Yes, there is.
These were the open reasons.
Yes, indeed. But if you scan back up the page to D,
yes.
The latter part of D, and this is 5 lines from the bottom of D, towards the right-hand margin, states shall identify those parts of the statement of case that may be publicly released, including for the use by the committee for the development of the summary described in H below, or for the purpose of notifying and informing the individual. So, yes, the recent practice of the committee has been to publish as it were, a publicly available statement of the reasons that it has for a particular decision.
These were the reasons which were communicated to Mr. Cardi and Al-Barakat, and on
Indeed,
which they were given the opportunity of making comments, which the Commission considered.
Indeed, and in this case, the reasons that were communicated to G by the Foreign Office.
That's right, I forget where they are, but we've seen reasons which are set out in
I think actually, if it's convenient in due course, they're set out in the Statement of Facts and Issues.
That's it, yes, thank you.
Well, while I have the guidelines in front of me, could I just respond to a slightly different point that Mr. Fordham made in the course of yesterday? He took you to paragraph D on page 5, and he suggested to you that the description of what should be in the statement of case made it clear that reasonable suspicion was not the standard to be applied when deciding, when the 1267 committee was deciding whether or not to add a person's name to the consolidated list. He took you in particular to subparagraph 1 within D. Perhaps I could just read the sentence, which is the second sentence of the paragraph, third line. The statement of case should provide as much detail as possible on the bases for listing indicated above, including, and Mr. Fordham relied on 1, specific findings demonstrating the association or activities alleged. I'd also draw attention to 2, the nature of the supporting evidence, e.g. intelligence, law enforcement, judicial, media, admissions by the subject, and then 3, supporting evidence or documents that can be supplied. Now, one sees from, again, the illustrative examples of the sort of information that member states are required to provide, that is entirely consistent with the application of the standard of reasonable suspicion. As indeed, one only needs to look at the Security Council resolutions themselves, which actually say that that is the approach, well, not reasonable suspicion, but they make the point that this system of sanctions is a preventative.
Well, you got it at 6C, hadn't you, under listing?
Indeed. And one has it also in the preamble to 1822. My Lord, one further point, just again in response to my Lord Walker's question from yesterday. There is, in addition to the 2 means of access to delisting that I've already taken you to, within the guidelines at paragraph 9, there is a process for review, compulsory review of all present cases. And there is, as it were, an initial review process, which requires a review of all names on the list by 30th of June 2010. And then further within 9 at B, there is a further requirement that in addition to that once-off review, that thereafter the committee conducts an annual review of all names that have not been reviewed in 3 or more years. So all names where there has been...
Where are we looking at the moment?
This is page 11 of the guidelines, my Lord, paragraph 9B. What happens on completion of the review exercise required by 9A.
And how many names are there on the list at the moment?
Yes, presently there are 513 names on the list. 400 that comprises 402 persons, and of those, 260 are associated with Al-Qaida and 142 associated with the Taliban. And there are also, making up the 513, 111 entities.
111 what?
Entities, so legal persons, but not natural persons.
That's some of the ones we see in the schedule to the council.
Yes, I don't know whether all on...
They have some banks or something like that, some financial...
indeed, yes, certainly one, yes. And in terms of the review process and the focal point process, again, just to provide some information into my Lord Walker's point as to whether or not the application of the measures was indefinite. As regards the use of the focal point, the present position is that there have been 16 requests made to the focal point.
From the United Kingdom, or
no,
generally?
Generally. And those 16 requests cover, some of them would be requests by one or more persons or one or more organisations. So it's not 16 people or organisations, but 16 requests. 12 of those requests have been determined to date. As a result of those determinations, 3 individuals and 12 entities have been delisted.
The individuals and
12 entities. And again, the outcome of those 12 applications was that 6 individuals remained on the list. Now that's the focal point. In terms of the review procedure, which is set out at paragraph 9 of the guidelines, and just to make it clear, that review procedure was itself introduced in response to criticisms, including those that appeared in the judgment in Cardi. There have been concluded reviews of 47 entries on the consolidated list. 4 names have been removed. I'm told that there are 4 additional names that it is expected will be removed from the list tomorrow, absent objection, and to date there has been no objection in relation to those 4. And there are 4 more cases where there is what's known as a technical hold has been placed on the review.
4 more with what?
4 more cases where a technical hold has been put in place. Again, difficult.
Couldn't you put all this on a single piece of paper and give it to us?
I will do, if that helps, yes.
We have a letter, which I think we were given yesterday or the day before, showing that Hay's name, Hay's name, was going to be considered on the 5th of October. Is that part of the process that you're describing?
Well, it's both part of the process, and it's something that's been specifically advanced by the United Kingdom following the decision of the Secretary of State. So the process was a useful opportunity for that application to be pushed forward.
As we saw originally, all he was told was that in the course of the process we will be making these representations. That was, I think, the information he was given.
Yes, and his comments were invited, and then the further correspondence made it clear that the Secretary of State was in any event going to consider this.
So Mr. Hay may be one of the 4 tomorrow, for all we know.
I don't think he is one of the 4 tomorrow. But I'm pretty certain he is not one of the 4 tomorrow.
Can you be, I mean, you obviously can be delisted if you should never have been on in the first place.
Yes.
Can you also be delisted if you've changed your mind, so to speak?
Yes.
You can.
Yes. And that is, I mean, from the Secretary of State's, from the Foreign Secretary's perspective, that is the position that exists as regards HAY. That's his position now is that he no longer meets the criteria.
You say this whole review process came in following Cardi, is this it?
Yes.
I mean, has there been a gradual, I mean, just getting the shape of it all, from when these resolutions first began to be made, post 9/11, initially no process for delisting, is this it?
No formal processes, no. It was a matter for the committee to determine itself.
Then it became formal.
Yes.
And then there was a focal point enabled in individuals or something to...
Yes, the significance of the focal point is that before the focal point, one could make an application via your state of residence or via your state of nationality. The focal point was a further option, which enabled you to get directly to the 1267 committee if you preferred not to go via your state of residence or state of nationality.
Then finally, this review process.
Well, yes, and the review process is yes.
I mean, it would be helpful just to have, just so we get away from some of the minutiae, which goodness knows we've been getting deeply into, and just get the shape of it all. I mean, you're saying that under the procedure in the United Nations, there is a gradual attempt to try and provide something akin to a process for, in effect, contesting your designation?
Yes, yes, matters have evolved and are evolving. And my lord, if it would help, we'll put in a short note which perhaps just identifies the staging posts.
It shows, if I may say so, the value of CARDI as a means of, as it were, nudging the process on towards a better recognition of the rights of individuals which are being infringed by, or may be infringed by, the orders that are made.
Indeed, my lord, yes, indeed.
So there is a process of dialogue, yes. And I suppose this case is part of that process.
Yes, indeed it is, yes.
But just with CARDI and the... I mean, was CARDI designated by the United Nations Committee, Sanctions Committee?
Yes, he was, yes.
Well, then, irrespective of the EU regulation, I mean, why wasn't he already subject to whatever these constraints are under some member states' laws? Hadn't they had to implement the resolution as far as he was concerned? Whose national is CARDI? Is he ours?
No, he's not.
Spain,
I think actually he's a Saudi national. I'm not quite sure where he was living. I suspect the proceedings were brought against the state of residence rather than the state of nationality in his case. I'm sorry, I don't know the precise facts of CARDI to that extent.
I don't understand quite why the EU are into this. Why isn't it all having to be done anyway, irrespective of what the community do, or the union do?
Yes.
Well, the EU's into it for the usual reason that although there may be an obligation competence at the national level, it's not clear that all countries will actually exercise it or do so properly. And the EU sometimes acts on that basis in order to ensure that there isn't a rather incongruous position where people are, there's a patchwork of enforcement at the of Security Council resolutions in this case.
Yes, I'm sorry. Yes,
I mean it's the same sort of thinking that's leading to moves to try and harmonise better criminal procedural practices. It's not that the European Convention doesn't already apply and require them. It's just that it's a rather more effective mechanism. The EU.
It was because a regulation was adopted, wasn't it? That was it prompted the discussion by the court in Luxembourg in CARDI, because it was looking at the resolution, the council resolution.
Yes.
Regulation.
Sorry, yes, the regulation was the response to the resolution, or rather the initial form of the regulation, the predecessor of 881 was that response.
They were seeking annulment, A&K were seeking an annulment of the regulation.
Yes. The position, I think, on the facts in CARDI was that under the predecessor of 881, which was in a similar format, let's say one had to be added to an annex by a community institution, Mr. CARDI was added to the annex to that preceding regulation. Then when Regulation 881 was made to replace the preceding regulation, all those who were already on Annex 1 to the preceding regulation were carried forward and automatically put into Annex 1 of Regulation 881. Yes. And so his challenge started as a challenge to the decision to add him to the annex to the previous resolution, and then continued as a challenge to his presence on Annex 1 to Regulation 881.
But it's open to the Commission, is it, not to include somebody even though they're designated under the UN resolution?
Well, I would suggest probably not. Could I take you to Regulation 881 and just show you the provisions?
Well, I mean, you've got to be more positive than that. I mean, it's completely contrary to all the submissions you were making before to suggest that there was any sort of choice at all. It was a binding obligation was your submission, wasn't it?
Well, that is my submission as to the position of international law. In terms of how things are particularly implemented, one needs to look at the implementing legislation. Hence, I think it would be helpful to look at 881.
The European Community isn't a member of the United Nations.
Indeed.
Then it's not. None of the resolutions is binding on the European Community.
Indeed, yes, precisely so, my lord. Yes.
Nevertheless, according to the narrative at the beginning of CARDI, the list which was annexed to the regulation was regularly updated. So they were doing their best to keep touch with what the committee was doing.
This is the point I'm trying to get to. If one looks at Article 2 and then Article 7 of Regulation 881, we see...
Let's look at it. Where is 881?
I'm sorry, it's volume 19 at tab 180. Article 2, all funds, economic resources, etc., held by any natural or legal person, group or entity designated by the Sanctions Committee and listed in Annex 881 in Annex 1 shall be frozen. So there are two conditions. You have to be designated and you have to be in Annex 1. And then Article 7 tells you more about Annex 1. The Commission shall be empowered to amend or supplement Annex 1 on the basis of determinations made by either the United Nations Security Council or the Sanctions Committee, and amend Annex 2 on the basis of information supplied by Member States. So, in direct response to my Lord Walker's question, what is clearly anticipated by Article 7 is that if a person's name appears on the consolidated list, the Commission will exercise its powers under Article 7 to add the name of that person to Annex 1. But one sees that it works in a way that the Al-Qaeda order does not work. It works in several stages.
But it's an option, empowered. The Commission is empowered. It's not impelled. It's not required.
Hence my initial caution in the answer I gave to Lord Walker, yes. But one would anticipate that ordinarily the Commission will exercise that power in order so that Annex 1 corresponds to the contents of the consolidated list.
We don't have the 28th November 2008 regulation, do we, which maintained or added Mr. Cardi back onto Annex 1? Because, I mean, that shows that it's now, at any rate, regarded as a matter for decision, i.e. evaluation followed by decision whether or not to maintain or add to the list.
Right.
Because they go through this process of reciting that they've considered the narrative summaries, they've considered the representations, and they've come to the conclusion that the listing is justified by reason of association with the Al-Qaeda network, and therefore they say he should be added to Annex 1. So now it's clear.
But, I mean, is it part of your case regarding Cardi that, I mean, as Lord Roger points out, I mean, the EU are not members of the United Nations. They're not subject, therefore, to the imperative constraints to implement the United Nations resolutions, and therefore, okay, if they want to enter this field, they can do so on their own terms, but not so with the member states.
Indeed, my Lord, yes.
Well, I hadn't appreciated that until just a moment or two ago.
How many of the member states actually have national legislation?
Well, I'll need to get instructions to answer that question.
It would be interesting to know whether...
Is this European Union member states? Or,
yes.
Oh, right.
Yes, I mean...
You don't mean all the members of the United Nations?
No, I meant European Union, because many of them may be relying on the Commission regulation as their compliance mechanism.
My Lord, we'll find out or add it to the note that we'll provide in response to Lord Brown's question. I can't avoid Cardi any longer, obviously. I haven't been doing a very good job at avoiding it so far. Could I make a number of preliminary points? Now,
Could we just see why we're into it now? There are two different bases for attacking the varies of the order, aren't there? One is that simply as a matter of construction, it's too wide.
Yes.
The other is that it involves a breach of the convention, because in making the order, an order has been made which infringes the Human Rights Act. Ergo, the order is void, isn't that right?
Not for this part of Mr. Singh's submission. This part of Mr. Singh's submission is only common law.
I see, yeah.
He only gets to rely on the Human Rights Act if he persuades you He says he persuades you that Al-Jeddah was wrongly decided. Yes. I say he also has to persuade you that quark fishing was wrongly decided as well. But for the moment, Mr. Singh's argument is simply based on the common law, and it's the principle of legality. He says access to a court, and he identifies the substance in this case as being access to a court to challenge the merits of the decision of the 1267 committee, but only on common law grounds. My first preliminary point on Cardi was to take you to Regulation 881, to show you Article 2 and Article 7, to see the structure of the regulation, and to ask you to note that it is different from the way in which the Al-Qaida order works, and in particular different from the way in which Article 3(1)b works. The next point is the point I made just a moment ago, that this is still on Mr. Singh's submission as it relates to the common law. Thirdly, Cardi was a decision which turned on the place of European Convention rights within community law. Again, in the context of a challenge to a measure adopted by community institutions in the exercise of their powers governed by community law. So, entirely a community law situation. Now, even if Mr. Singh's submission on this part of the argument is assumed to include the Human Rights Act and Convention rights, so even if one assumes that, we say that the outcome in Cardi would not be reproduced as a matter of English law. And the reason for that is not, as Mr. Singh suggested, because of the principle in Ullah that domestic courts should not construe the effect of convention rights beyond their construction and application by the Strasbourg court itself. It is in fact because of the proper construction of the Human Rights Act and the meaning of convention rights within that act. And that was the matter determined by the House of Lords in quark fishing. We've set out the references to quark fishing and also to the same argument which was considered by the Court of Appeal in Al-Jeddah in our printed case at paragraph 70. And if you have that to hand, I'd be grateful if you could look at it briefly.
This is your case.
I'm sorry, in G, my Lord, yes.
Paragraph 70.
Yes. And my Lord, I've taken to it simply because we've got the references there. And the proposition is that on a proper construction of the Human Rights Act, no claim for a breach of a convention right could be maintained under Section 6. Then, quote, unless the convention right is one for which the United Kingdom will be answerable in Strasbourg. And the references there to the speeches in quark fishing, and also to the judgment of Lord Justice Brooke, which was in fact the judgment of the court in Al-Jeddah. Now, before the Court of Appeal in Al-Jeddah, that was still a live issue. By the time Al-Jeddah got to the House of Lords, it was not a live issue because of quark.
But I think that, I mean, that seems, on the face of it, difficult to reconcile with P, I think, because in P, although it may be obiter, and the majority of the members of the court said that if a matter fell within the margin of appreciation from the Strasbourg viewpoint, nonetheless, since it was a convention right, a domestic convention right, which was justiciable in this jurisdiction and was one on which the courts of this jurisdiction had to decide the application, it might be justiciable here.
Well, with respect, that's a different point. That's the Ullah point.
Yes, I see.
Quark is dealing with a different situation where...
Quark is dealing with territorial scope of the...
Well, quark itself was dealing with territorial scope, 180, but the point of principle as to the construction of the Act was reliance on the fact that convention rights are identified as being those rights to which the United Kingdom is subject under the Convention from time to time.
Yes, I see. So
Now,
I'm sorry, I may have been interpreting the word answerable, or assuming you were interpreting it more widely than you are.
No, actually, the quotation is from my Lord Hope's speech in Quark, but I'm sure that
well, it's in P as well. But I mean, the problem in P was that we were going rather further, I think, than existing jurisprudence had gone in Strasbourg. But I think we thought that was the way it was going to go anyway, and we should take the plunge and say what we said.
But the position in Quark and in Al-Jeddah, again, it draws in the effect of international law of Article 103. If the effect of Article 103 in a particular situation is to displace a right within the Strasbourg system because of the effect of Article 103 on all other international agreements, that means that the United Kingdom could not be held answerable in respect of that displaced right by the Strasbourg court. And for that reason, that is not a convention right for the purposes of the Human Rights Act, properly understood. That's the reasoning and the conclusion in Quark and then applied to Al-Jeddah, although Quark itself was the territorial example.
But we're back to Bosphorus, aren't we?
This is Bosphorus in the Strasbourg court.
Yeah.
My lady, I would suggest not. May I deal with that a little later? But Bosphorus, in short, we say the Strasbourg court was dealing with a very different state of affairs. Returning to Cardi, there is no equivalent within community law of that Quark principle as to the scope of convention rights being affected by, indirectly, the effect of Article 103 of the Charter as a matter of international law. Now, the one obvious reason for that, and the reason why it's in no way mysterious that Article 103 does not form part of the reasoning of the court in Cardi, is, as my Lord Roger indicated, the community, the European Union, is not a member of, is not subject to the United Nations Charter. It's not a member of the United Nations, and so Article 3 is entirely immaterial for the purposes of the community. With those points in mind, and bearing in mind also that Mr. Cardi's decision, that Mr. Cardi's challenge was to the decision to include his name in Annex 1, which was a decision taken by a community institution. Could I ask you to go to Cardi, which is in volume 13 of the authorities at tab 105. Could I also ask you to look at a passage in our printed case, please? The submission that we make as to the effect of Cardi is set out in paragraph 76 of the printed case in G, and I hope it will assist if you have that in front of you as well. The relevant part of the judgment in Cardi, as Mr. Singh indicated, is between paragraphs 278 and 330. And 278 starts on page 1280 of the report. And paragraph 76 of the printed case, we set out a number of propositions that we say are correct in respect of the approach and the judgment in Cardi. The first of those points is the obvious point that the Court of Justice was only concerned with issues of community law and only concerned to review the legality of community legislation. Now, the Court takes as its starting point the proposition that acts of community institutions should be subject to review by the Court in accordance with community law, and one sees that rather basic proposition made good paragraph 281. In this connection, it is to be borne in mind that community is based on the rule of law inasmuch as neither its member states nor its institutions can avoid review of the conformity of their acts with the basic constitutional charter, the EC Treaty. The Court also made the converse point to that it accepted that it had no jurisdiction to review the legality of decisions taken by the Security Council, pursuant to the Charter. And so the Court of Justice draws a clear distinction between community law and international law, and identified its jurisdiction as going only to review by reference to the, by reference to community law of the legality of actions by community institutions. And in particular, one sees that at 287 and 288. 287, the Court expressly states that it is not for the Court to review the lawfulness of a resolution adopted by an international body, even if that review were to be limited to examination of compatibility with Jus Cogens, so rejecting the Court of First Instance approach.
So Article 220 EC defines the extent of the jurisdiction of the court.
Indeed.
And it doesn't include this kind of review.
Indeed. And so, again, for present purposes, the community court is looking only at the community measure and only judging the legality of that. Transposed for a moment the common law, we say that the common law, again, should focus only on the domestic measure, which obviously we identify within the Al-Qaida order itself. And then at 288, then says, however, any judgment given by the community judicature deciding that a community measure intended to give effect to such a resolution is contrary to a higher rule of law and community legal order would not entail any challenge to the primacy of that resolution in international law. And again, that must be right, and we would suggest precisely the same principle would apply if one took out the words community law and wrote in the words common law. The third point we make is as to what the court said as to the content of community law. And in particular, the court made the point that fundamental rights formed an integral part of community law, and that the ECHR had a special significance within the law such that compliance with it was a condition for the lawfulness of community acts. One sees that at paragraphs 283 to 284 of the judgment. And the court made the further point that, again, as a matter of community law, the power of community institutions to act under Article 307 of the EC Treaty was subject to the provisions of Article 6 of the EC Treaty. And that proposition is set out at paragraph 304 of the judgment. So in terms of the content of community law, the court recognised ECHR rights as being a key part of the content of that law. But I'd ask you to note that it did so by reference to Article 6 of the EU Treaty. There is nothing within Article 6 of the EU Treaty which identifies the place within community law of fundamental rights that is equivalent to the provisions of the Human Rights Act as construed in Quark. That is to say, equivalent to a provision that limits the availability of convention rights to those rights for which the UK would be answerable in Strasbourg. So there's nothing that actually permits effect to be given to Article 103 of the Charter and the effect that that has. We say that's entirely unsurprising because the EC is not itself a member of the, a signatory to the Charter. The court then considers the relationship between community law and international law, and that's the passage between 305 to 309, and it concluded that the primary community law, which included Article 6 of the treaty, prevailed over obligations arising under an international agreement. And then the overall conclusion of the court is at paragraph 326, where it says that it follows from... 26, my lord. It says it follows from the foregoing that the community judicature must, in accordance with the powers conferred on it by the treaty, ensure the review, in principle the full review, of the lawfulness of all community acts in the light of the fundamental rights forming an integral part of the general principles of community law, including review of community measures, which, like the contested regulation, are designed to give effect to resolutions adopted by the Security Council. Now, properly understood, we say that the conclusion reached in Cardi rested on, firstly, a rationale that the treaty itself, the EC treaty, is an autonomous legal system, not prejudiced by the consequences of any other international agreement. Also, that the rights under Article 6 of the EU treaty, that's the recognition of the role of the convention rights within community law, form part of that autonomous system.
Sorry, could you repeat that second point?
So, yes, the rights arising and recognised by Article 6 of the EU treaty formed part of that autonomous system. And so the clear point of distinction between the position under community law and the position under English law stems from the respective effects of Article 6 of the EU treaty in the former and the provisions of the Human Rights Act in the latter.
Right, what's the latter?
The latter is the position of convention rights within English law. Yeah. So, from the perspective of community law, it simply wasn't relevant to ask the question, what result would the Strasbourg court have reached? More specifically, the question is, would the Strasbourg court have recognised that recognised a particular right as being a right that was enforceable before it? There's no need to ask the Article 103 question. Of course, because of the provisions of the Human Rights Act in English law, that is a very important question to ask, as it goes to identify the extent of what is meant by convention rights from case to case. And again, it is notable that there's no mention of Article 103 in any part of the reasoning of the court in Cardi, and as I've said earlier, the reason for that is simply it was not a relevant consideration. Now, we also place emphasis on what actually happened in Cardi, and this is the passage in the judgment from paragraph 331 at the bottom towards the bottom of page 1287. Paragraph 333 says it is appropriate to examine first the claims made by Mr. Cardi and Mr. Al-Barakat with regard to the breach of the rights of defence, in particular the right to be heard and the right to effective judicial review. So those were his specific claims. Paragraph 334, in this regard, in light of the actual circumstances surrounding the inclusion of the appellant's names in the list of persons and entities covered by the restrictive measures contained in Annex 1 to the contested regulation, it must be held the rights of defence, in particular the right to be heard and the right to effective judicial review, were patently not respected. So that's the conclusion. And then the reasons for that are explained at 336. And if I could ask you to pick up that paragraph after the quotations at the beginning of the paragraph. It must be held in this instance that the effectiveness of judicial review, which it must be possible to apply to the lawfulness of the grounds on which in these cases the name of a person or entity is included in the list forming Annex 1, and leading to the imposition of those measures, the imposition on those persons of restrictive measures, means the community authority in question is bound to communicate those grounds to the person or entity concerned. Now, if the statement at 336 were, as it were, recast as if it were a statement about the common law and about the circumstances of the Al-Qaida order, the grounds that would be communicated to the person would be the fact that, in this case, G's name appeared on the consolidated list,
Sorry, the fact that G's name is on the list
On the
maintained by
consolidated.
the committee.
Yes, that effectively would be, as it were, the reason for the decision. And if one looks at paragraph 337, it's important to note that in that paragraph, all the court was concerned about was the legality of the community measure. So in that case, the decision to add Mr. Cardy to Annex 1. Now, the equivalent measure in English law, in the context of the Al-Qaida order, is Article 3.1b itself. That's, again, the decision that the order applies if you're identified on the consolidated list.
But it's very difficult to think the European Court would have decided the matter differently if the regulation had followed the form of 3.1b of our domestic law.
Well, two points, Warren. Firstly, we suggest that it would have done. 3.1b is clearly an effective means of, it's clearly a more direct means of giving effect to the decision of the Security Council. But it's also important to note that the approach of the court in Cardy is not the approach that Mr. Singh contends for in this case. It didn't provide for a merits review of the decision taken by the Security Council or the 1267 Committee. And indeed, yes. So, well, I would suggest.
Well, I thought Mr. Singh's argument was that you couldn't provide for that, but you had to introduce something at the domestic level, a rerun of the point.
Well, that's Mr. Singh's submission at that point of his argument, but he then goes to say, well, if you do introduce that, well, then you can't have an effective remedy in respect of that right, because the domestic court can't require the 1267 Committee to take a decision. Therefore, the Al-Qaida order on his submission is still ultra vires, is still unlawful. And so Mr. Singh, on the one hand, says, I've got to have this ability to challenge the 1267 Committee, but then he says, once I've got it, that's the reason why the Al-Qaida order is ultra vires.
Yes, I mean, I think he would say that the only valid type of order would be one along the lines of the regulation.
Which comes back, my lord, I think, to the fundamental questions. Firstly, the question of vires within Section 1 of the 1946 Act. And secondly, whether the actual use of that power through the Al-Qaida order was a use that was inconsistent with the common law principle that Mr. Singh rests his submissions on, which is the principle of right of access to a court. Again, I don't wish to repeat myself, but that principle attaches to an ability to question before the court the legality of domestic measures. And so one falls back to the question, what is the domestic measure? And what is the meaning of Article 3.1b? While you have Cardy in front of you, could I also just ask you to look at 361 and 363? Sorry, 361 and 363, still within Cardy, my lord. I mentioned these paragraphs to you in the course of my submissions on A, K and M. They're simply the paragraphs where the court repeats and then applies the reasoning it's adopted in Bosphorus as to the proportionality of sanctions, even though they have an impact on third parties. Those are the particular paragraphs that I referred to in the course of those submissions. My lord, before I get to part 3 of my submissions, which is concerning Al-Jeddah, could I deal with Mr. Fordham's submission based on paragraph 30 of the Advocate General's opinion in Cardy? And I'll deal with this relatively quickly, or at least I'll attempt to deal with it relatively quickly.
Could we find that paragraph, just to remind us?
Yes, of
paragraph
course.
30, you say?
Paragraph 30, I think, was the basis of his submission, which should be page 1229.
Yes, it is. Yes.
Now, firstly, it's important to note that that thought, that reasoning, forms no part of the reasoning of the court itself. Respectfully, we would also adopt the observation made by Lord Mance yesterday afternoon to the paraphrase here, that it was an ambitious argument, because on the one hand, there is an acceptance that this is not an area of exclusive community competence, but on the other hand, it is to say that it is an area in which the actions of member states are, as it were, directly governed by community law. That is a difficult argument and by no means an obvious one. But as I say we don't need that simply because of the first point, that this chain of reasoning simply was not adopted by the court and was not the basis on which the court...
It didn't have to. I mean, this is speculation about what member states could do, which was actually irrelevant to the court. But it's quite just looking at the power of member states to act to maintain international peace and security. Seems to rest on Article 60, which is one of the bases of jurisdiction for the CARDI regulation also. But it says, without prejudice to Article 297, and as long as the Council has not taken measures pursuant to paragraph 1, a member state may, for serious political reasons and on grounds of urgency, take unilateral measures against a third country with regard to capital movements and payments. I mean, there is a qualification as long as the Council hasn't taken measures, but assuming, I mean, the Advocate General's argument seems to be, all right, they could still take measures, but could only do so consistently with community law. I've looked at ERT and I still think it's an ambitious argument, but nonetheless, yes. I mean, are we to exclude it? I'm afraid the thought crossed my mind that it's our duty to think about these things to some extent of our own motion, and this is pretty sort of limited way of arguing the point, which doesn't seem to me very satisfactory. I mean, theoretically, there might even be a question of a more fundamental, well, I suppose perhaps it is Mr. Fordham's point, as to the validity of this whole national attempt to legislate, although actually the timing is the other way around, because the EU regulation came after, at least in 2002, after the domestic regulations.
Well, we do say it's an unsatisfactory way in which this matter has been brought before the court. It's never been any part of the Appellant's case, of G's case. It's something that arises really in passing in the course of the intervener's case. It's not a point on which the intervener specifically applied to intervene, at least if yes, the terms of the intervention did not indicate that this argument was being raised. And in those circumstances, firstly, it's an unnecessary point to consider, because the argument that I do squarely face is the argument either that CARDI means that Al-Jeddah should be reconsidered, or that CARDI is a sufficient analogue such that the common law should be applied to produce the same sort of result.
But the reason why the point is troubling is that there is an incongruity, it seems to me, about a situation where the EU has acted, or the EC actually has acted, and has, following a common position taken by under the EU treaty, and has dealt with the matter in a certain way, which it has amended in the light of a European Court decision, and is proposing to amend further. I notice there's a current proposal to amend 881. And yet national countries can go along and introduce their own domestic regimes, which are inconsistent with, more extensive than, have less fundamental rights guarantees. Would the European Court of Justice really regard it as unarguable, this point? Would they really say it's absolutely clear that, that national countries can maintain their own national systems?
I hadn't appreciated we were being asked to refer a question on this, are we?
Not so far.
No, but I mean, it's our duty to think about these things.
Well, my Lord, I would suggest that some of the premises within the observation you just made are not necessarily correct. And in particular, the idea that the result in Cardi is in some respect more fair than the result for which the Treasury contends in this case. Again, the basis on which Mr. Singh's submission is made is the principle of the right of access to a court. And that principle operates as a matter of English law on the basis, because it is directed to, it has the effect that decisions of executive bodies within domestic law should be subject to the scrutiny of the courts. Now, that is the relevant principle of fairness within English law. Now, in the present case, obviously, my submission is that principle of fairness is fully satisfied because of the availability of a challenge to Article 3(1)b itself. Now, whether one regards that application that consequence as better or worse than the application of community law to the actions of a community institution by the community court, I would suggest is really neither here nor there. The question for this court is the legality of that situation as a matter of English law. And it's not a question of the word fairness as a pejorative or other term. It's a question of fairness as a specific legal concept, which must be identified on a principled basis. Mr. Singh does that by relying on the principle of access to court. I say that one has to apply that principle properly to the domestic measure in this case. So I wouldn't agree that the result in Cardi is any fairer or less fair than the result in the present case. And I do make the submission, and I already have made, that if one looked at what happens in Cardi from paragraph 331 to 337 and asked, well, if one put in the Al-Qaida order and the common law to those paragraphs, would you get a different result? The answer is no. You would still not get a result where the domestic court was required to consider the legality of a decision by the 1267 committee as a precondition for the legality of domestic secondary legislation. It's simply a question of construing the legislation as made. But, I mean, I would suggest that if this point, as mooted by the Advocate General, paragraph 30 of his opinion, is to be taken any further, it's really not satisfactory to do it at this stage within this case. It's not something that's been a feature of this case. And as my Lord, as you indicated, if there were any substance to it, I don't accept for a minute that there is, but if there were, well, it would be a significant point in the community law field. So I was going to move now to the third part of my submissions, if that's convenient, which concerns Al-Jeddah and the suggestion that Al-Jeddah was incorrectly decided. Obviously, the conclusion in Al-Jeddah concerned the effect in international law of Article 103 of the UN Charter. Now, Mr. Singh did not in his oral submissions suggest that that decision on that point had been shown to be wrong by the judgment in Cardi. And for the reasons that I've already stated, that is not the effect of Cardi. Cardi was not concerned with Article 103 of the UN Charter. The EC is not a party to the Charter. Now, Mr. Singh's submissions on this point were simply to the effect that if Article 103 had the effect identified in Al-Jeddah, there could be, as he put it, unpalatable consequences. Now, with respect, that does no more than repeat the arguments that were made before the House of Lords in Al-Jeddah itself less than 2 years ago. Mr. Singh took you to the relevant parts of the speeches and said that one sees from some of those speeches, or rather he infers from some of those speeches, that the makers of the speeches found the point a difficult point. Well, that's hardly...
Sorry, I lost that.
So,
can you speak up a little?
I'm sorry. The speeches suggest that those who wrote them thought it was a difficult point. Well, that's hardly surprising. It was a point before the House of Lords, and it was a point that was closely argued before the House of Lords. Goes without saying. But nothing that Mr. Singh says now about unpalatable consequences takes the debate any further. It also, and this is my second point, his submission also ignores clear international law opinion as to the effect of Article 103 as a matter of international law. Now, this again was deployed in argument before the House of Lords. It's actually set out in more detail in the judgment of Lord Justice Brooke in the Court of Appeal. The references are given. Could I ask you just to look at that? Al-Jeddah in the Court of Appeal is in volume 8 of the authorities. And within volume 8, it's at tab 60, 60. Could I invite you to turn to page 647 of the report, please? Firstly, at paragraph 68, just to get the context of all of this, at paragraph 68, Lord Justice Brooke sets out the submissions that were advanced by Mr. Starmer on behalf of Mr. Al-Jeddah. And you see between B and C on the page that 3 points were relied on. That firstly, no obligation arising out of Resolution 1546. Secondly, the Charter imposed obligations on every member state to protect human rights. Article 3 had no application when two obligations created by the Charter itself were in conflict. Now, in relation to international opinion as to the effect of Article 103, Lord Justice Brooke sets out at paragraph 69 and paragraph 70 the relevant parts of the commentary in SIMA, the commentary on the Charter of the United Nations. Could I invite you to read paragraphs 69 to 70 and then also paragraphs 71 to 72, please?
Where did you want us to go to?
I'm sorry, only as far as paragraph 72, please, my lady.
I think some of us are going a bit further.
Oh, I was then going to take you more briefly to 75 to 80. I think that the relevant, if you're going further, I think the farthest you need to go, I think, is paragraph 80, subject to better bids.
up to 84, in effect, really. Sentences of 84.
Thank you, my lord. But we place particular reliance on the passage quoted from, written by Professor Bernhardt, which is set out by Lord Justice Brooke at paragraph 70. As Lord Justice Brooke indicates, Professor Bernhardt was himself a previous president of the Strasbourg Court, and yet when he is explaining the effect of Article 103 of the Charter, he does so in very clear and in very absolute terms. Now, that, of course, is also entirely consistent with the Strasbourg Court's own case law. This is my third point. Again, I would draw your attention to the passages in Barami that I took you to earlier this morning. Barami, for your note, it's volume 16, tab 130, and it's paragraphs, it's 147 to 149, including the reference back to paragraph 27. Now, again, given the context in which it is said by Mr. Singh that one needs to revisit Al-Qaida, that is to say, because there could be, as he put it, unpalatable consequences in human rights terms, the view expressed by the Strasbourg Court as to the effect of Article 103 must be a very important matter. And there is simply nothing in that view that suggests that Al-Qaida, as decided by the House of Lords, was incorrect. As Mr. Singh indicated, and as we set out in our printed case, the Al-Qaida case is itself going through the processes prior to a hearing before the Strasbourg Court. Now, of course, if that court took a different view, reversed its previous jurisprudence as to the effect of Article 103 for the purposes of the Strasbourg system, such a decision may well be something that might prompt this court to look again at the conclusion reached by the House of Lords in Al-Qaida. But unless and until that happens, there is nearly no basis for going back to and revisiting a decision taken a matter of months ago by the House of Lords. There is certainly no compelling reason. Well, put two ways. Firstly, Al-Qaida is not wrong. That is clear. And secondly, even if it was, there is no compelling reason for revisiting that decision at this stage. Now, Mr. Fordham advances a separate point, and this is the Bosphorus point. He says that the conclusion reached by the House of Lords in Al-Qaida as to Article 103 was unnecessary because of the decision of the Strasbourg Court in Bosphorus. Now, we say that Bosphorus was in fact dealing with a very different situation. Could I ask you to look at the report of the case, please? It's volume 16, tab 130. Now, before the Strasbourg Court, Ireland's response to the claim was that it had to act in the way that it did as a matter of community law, and indeed as a result of the decision of the Court of Justice in the previous Bosphorus case. And one sees those circumstances being set out by the court in this judgment, firstly at 147 to 148. 147 is on page 42 of the report. And one sees at 147 the court saying the court would also agree with the government and the European Commission that the Supreme Court, that's the Irish Supreme Court, had no real discretion to exercise, either before or after its preliminary reference to the ECJ for the reasons set out below. In the first place, there being no domestic judicial remedy against its decisions, the Supreme Court had to make the preliminary reference it did, having regard to the terms of Article 177. And then the second is at the top of page 43. Secondly, the ECJ ruling was binding on the Supreme Court. And thirdly, the ruling of the ECJ effectively determined the domestic proceedings in the present case. Then at 148, for these reasons, the court finds that the impugned interference was not the result of an exercise of discretion by the Irish authorities, either under EC or Irish law, but rather amounted to compliance by the Irish state with its legal obligations flowing from EC law, and in particular Regulation 990/93. And to the same effect at paragraph 150 on the next page, the court considers it is evident from its findings at 145 to 148, immediately above, that the general interest pursued by the impugned action was compliance with legal obligations flowing from the Irish state's membership of the EC. While you have the judgment in front of you, could I also ask you to look at 157? Now, at 157, the court was dealing with an argument as to attribution, as to whether Ireland was in fact responsible for the alleged breach of convention rights. And it concluded that it was. It says it remains the case a state would be fully responsible under the convention for all acts falling outside its strict international legal obligations. The numerous convention cases cited by the applicant confirm this. Each case concerns a review by this court of the exercise of state discretion which EC law provided. Pellegrini case is distinguishable. The state responsibility issue raised by the enforcement of a judgment, not of a contracting party to the convention, is not comparable to compliance with a legal obligation emanating from an international organisation to which contracting parties have transferred part of their sovereignty. And so the court sees this as being a particularly peculiar and difficult situation. And in that context, to deal with the relationship between the Strasbourg system and the European community, the court did determine the case by asking whether the protection for ECHR rights under EC law was equivalent to that available before the Strasbourg court itself. That's the only context in which this issue of equivalence is a relevant issue. Now, in the present case, of course, in Bosphorus, I should also say, the Strasbourg court did not need to address Article 103 of the UN Charter, again because the community is not a member of the United Nations. The present context is, of course, entirely different. The relationship...
Sorry, I'm lost.
I'm sorry.
Ireland had no option under EU law to do what it did, but to do what it did. What does Strasbourg say the result of that is?
The ultimate result of that was that the court concluded that the protection afforded to convention rights within community law was sufficiently equivalent such that Ireland's act in compliance with a requirement of community law was an act that was consistent with convention requirements.
So what does it teach us on the point we're concerned with? I mean, that doesn't bite on what we're talking about at all.
Well, precisely my point, Murray. It teaches us nothing about this case. The present case is one where there is a specific international rule as to the effect of obligations arising under the UN Charter on obligations under any other international agreement. That's Article 103. That rule is specifically applicable to this case and should simply be applied.
If one looks at the top of that page, the state, I mean, the argument, as I understand it in Bosphorus, was that where a state, having already been bound by the convention, then enters into other obligations by which it transfers part of its sovereignty to something else, in that situation, it remains liable under the convention in respect of those things which it's transferred. It can't get rid of it.
Indeed.
But here, we're not in that situation because the UN Charter was entered into years before the convention, for one thing, and anyway is said to be, Article 103, said to be dominant. And so on.
Well, indeed, by the way, again, one doesn't need to look at Bosphorus very closely at all, because we know what the Strasbourg court would do in a case such as the present. We know that from Barami. It would apply Article 103.
We surrendered our sovereignty in this respect in 1945 when we signed up to the Charter.
Precisely, my lord. On those four reasons, we say there is simply no basis for concluding that Al-Jeddah and the decision in that court, that case as to the effect of Article 103 in international law needs to be questioned or revisited at all. Now, if that conclusion is accepted, or that submission is accepted by this court, then Mr. Singh's reliance on convention rights obviously falls away. The effect of Al-Jeddah, together with the judgment of the House of Lords in Quark, is that Mr. Singh is not able, in respect of the Al-Qaeda order, to assert that Article 7 or Article 8 of that order are unlawful because they are in breach of convention rights. All he is left with is his common law argument, the argument based on the application of the common law principle of access to a court. I was going to turn now to the fourth part of my submissions, which is the question of effective remedy, and incorporating within that submissions on the HAY case. Now, if this court accepts my first submission as to the correct application of the principle of the right of access to a court, the issue as to the existence of an effective remedy does not arise. On the Treasury's submission, access to the court should be in respect of the provisions of domestic law and decisions taken by domestic public authorities in exercise of those powers. And if that is applied properly to this case, the principle is satisfied. Now, on that analysis, the court clearly could address any relief thought necessary in respect of any claim to an appropriate public authority, and there would be no basis for saying that that was in any sense, any relevant sense, ineffective. And we summarise we summarise possible factual scenarios at paragraph 57 of our printed case. If I could ask you to turn to that, please.
We're looking at
a G case again.
G case again.
Yes.
57.
I won't go outside G without telling you. Now, paragraph 57, it's the sub-paragraphs within that. Actually, I'm sorry, the reference should be paragraph 56, I think. But one can assume several possible scenarios.
56, are we at?
I think 56 and 57. I'm sorry, I'm getting confused by my own printed case.
I think 57 is relevant, but I think 56 is the starting point.
Yes. There are various possible situations. The first could be a challenge to an action taken under the Al-Qaeda order, for example, a direction under Article 4. That is subject to challenge before the courts because Article 5 says so, and now Section 63 of the Counter-Terrorism Act says so. No question at all about that. Another possibility is that there might be decisions taken by public authorities in connection with the operation of the Al-Qaeda order. One such decision might be, for example, a decision to seek the listing by the 1267 Committee of a person who was resident in the United Kingdom. Now, that decision, in principle, is subject to judicial review under ordinary principles of judicial review. A further situation could be, take the situation of somebody who is already listed by the 1267 Committee. He could invite the Foreign Secretary, for example, to make an application on his behalf to delist. And the Foreign Secretary might decline to do that. And that would be a decision which, as a matter of domestic law, was in principle susceptible to judicial review. Now, of course, there would be potential complexities that could arise in connection with such claims. The obvious point mentioned by Mr. Singh is in relation to possible remedies, as the judgment of the Court of Appeal in Al-Rawi makes clear, that when it comes to exercising the discretion as to remedies, the court will be sensitive not to trespass upon matters which genuinely involve the conduct of foreign affairs. And so there may be issues for the court to consider from case to case. But none of those matters would be such as to suggest that the decision taken by the domestic public authority in exercise of domestic law powers was anything other than subject to review and legal scrutiny by the courts. So the point that follows is that the appellant's submission, G's submission, that there is an ineffective remedy, only arises if G's first submission is accepted, and that is to say that he should have a claim before the English court that is directed to the merits of a decision taken by the 1267 committee. And from this starting point, what both G and HAY say is that the remedy that a court could grant on such a claim, the claim they contend should exist, is ineffective because the court cannot require the 1267 committee to remove their names from the consolidated list. That's the case that's being advanced. Now, as I say, our primary point is that you simply don't need to address this, because if you accept our submissions on the access to court point, no question of ineffectiveness arises. But we have an alternative point as well. Assume that the analysis of the Court of Appeal, the Master of the Rolls and Lord Justice Sedley, as to the need for this right of challenge to the 1267 committee decision as a precondition for the legality of the Al-Qaeda order. Assume that's right. In that situation, we say that the fact that a court on such a claim is unable to grant relief that is directed to the 1267 committee itself does not render the remedies that are available to the court in any relevant sense ineffective. It certainly does not require the court to quash the Al-Qaeda order as being ultra vires Section 1 of the 1946 Act. Now, all the remedies that would normally be available to a court on a claim for judicial review would remain available to the court in response to the claim that was posited by the Master of the Rolls and Lord Justice Sedley. The remedies available would not in any way be limited by any provision of the Al-Qaeda order itself. Again, the court would retain its full powers to grant such relief as it thought appropriate against any UK public authority. As I say,
where do you set out this fallback position? Assume the Court of Appeals approach is right, you're still okay. Where do you set that out?
I'm not sure I do set it out in the terms I've just made it in the G printed case, and I apologise for that.
It seems to be a bit of an odd submission. I mean, assume that the remedies, a further remedy is required. The absence doesn't make remedies ineffective. It seems to some amount to. It seems to be self-contradictory. You said assume that a right of challenge to a 1267 committee decision is required. In other words, assume that a further remedy is required. The absence of that remedy doesn't render remedies ineffective.
That's not quite the way I'd put it, and I've garbled it. One has to assume for present purposes that there needs to be the opportunity before the English courts to consider the merits of the 1267 committee decision.
Yes.
It's then said that because the court based on many legal principles, simply cannot require the 1267 committee to take a decision.
Yes.
Well, that means the remedy is ineffective, and so you shouldn't bother with shouldn't bother with the existence of the cause of action at all. And so it's sort of the reverse of a have your cake and eat it argument on the part of the appellants. The only point we make is that if the appellants are right, and if the Master of the Rolls and Lord Justice Sedley were right as to the necessity for this aberrant cause of action directed to the 1267 Committee, if they're right about that, it's bizarre then for the appellants to say, well, that cause of action isn't effective because I can't get from it something that I have never been able to get from any English court. That is to say, for example, a mandatory decision directed to the 1267 Committee that required it to take a particular decision. I appreciate that this submission only arises in circumstances which on our submission are wholly extraordinary. But if it does arise, it seems rather unfair to criticise on the basis of effectiveness when the court has never had the power to give specific direction to any international body, but retains its full powers in respect of all domestic authorities, and none of those powers are removed by any provision of the Al-Qaida order. Turning to the points made by Mr. Hussain in respect of HAY, and on the HAY case, we make two broad submissions. The first of those submissions, of course, flows directly from what we have already said in respect of G, as to the principle of access to a court. In HAY, the judge's starting point was that the principle of access to a court required the court to scrutinise the merits of the 1267 Committee's decision. Now, if our submissions on the G appeal are accepted, clearly that was a false starting point. And so for the reasons already given, it would inevitably follow that the judge's conclusions in HAY were incorrect.
You'd say he was led astray by the Court of Appeal?
Yes. That's one way, yes.
Well, trying to be fair to Mr. Justice Owen.
Sorry, I wasn't...
His decision did follow the Court of Appeals in G.
Well, that's the assumption I make for the purposes of this first submission, that it did follow that. But clearly, if as I say, if the G submission is accepted, well, the exercise that all of us undertook in HAY was an unnecessary exercise. The second point, and this is the further point, is even if you reject that first point, and again assume the Court of Appeal analysis to be correct, the judge's conclusion on the facts of that case, that there was no effective remedy, was incorrect. It is important to bear in mind that by the time of the hearing before Mr. Justice Owen, the Foreign Secretary had already determined that he would make and support an application to the 1267 Committee in respect of HAY. And so the facts at the time of the hearing before Mr. Justice Owen were exactly the same as if the court had undertaken the sort of merits review anticipated by the Court of Appeal and had found in favour of HAY. Now, the judge's conclusion was that the fact that the United Kingdom was making such an application on behalf of HAY nevertheless meant that HAY had no effective remedy, and that was based on a conclusion stated by the judge that the Foreign Secretary was not himself privy to information relied on by the 1267 Committee when it took its original decision to add HAY's name to the consolidated list. That was the decision in October 2005. And that's the judge's judgment at paragraphs 30 and 31. That conclusion was simply incorrect. As is clear from the resolutions and the guidelines that you've seen, the United Kingdom is effectively a permanent member of the 1267 Committee, because the 1267 Committee is a committee of all members of the Security Council, and the United Kingdom is a permanent member of that Security Council. Now, on that basis, by reason of its membership of the 1267 Committee, the United Kingdom had access to all information relied on by the committee when it took its decision. Now, it's important to understand that the issue that was dealt with in correspondence before the hearing in HAY only concerned what information could be provided to HAY and his legal advisers. And the point that was being made by the Foreign Secretary in the course of that correspondence was that he could only provide information if he had the consent of the 1267 Committee to provide that information to HAY. So the Foreign Secretary wasn't saying, I don't have it. The question was, I need the consent of the 1267 Committee. And ultimately, that consent was granted in respect of some of the information, and that information was provided to HAY and his legal advisers. Now, when in June this year, the Foreign Secretary agreed to make the application on behalf of HAY, the 1267 Committee, clearly he would have had in mind the possibility that when that application came before the 1267 Committee, there might be further information put forward by any other member state relevant to that application. And so when the Foreign Secretary in his decision underlined the point that he'd taken the decision based on the information available to him, all he was doing was making clear that in future further information could come forward, hence he could not guarantee that the decision that he had taken as to whether HAY met the criteria would necessarily be repeated and replicated by the 1267 Committee. And that was the point made at paragraph 14 of the Treasury's skeleton, which is the paragraph that Mr. Hussain sets out in his printed case. And that was the point made by Mr. Roberts at paragraph, in his witness statement, which is quoted at paragraph 47 of Mr. Hussain's printed case. And so the judge was incorrect to assume, indeed to conclude, that the Foreign Secretary was not privy to information. And on that basis, there was no reason to suggest or to conclude that the exercise that was envisaged by the Court of Appeal in this case, the exercise of an application being made on behalf of a person to the 1267 Committee, would not be as effective in HAY's case as theoretically it could be should the situation arise in G's case. My Lord, is that a convenient moment?
Yes, we will, Judge.